In the previous section, you begin to hear about Title 24, which covers the law and regulations related to security guards in Delaware. Those topics obviously cover the technical points of the job. This section will dive deeper into providing you with an understanding of the law, in particular Title 11, which is the Delaware Criminal Code. In the last section, we covered how a security guard is legally defined. Here we will explain what legal authority you possess as a security guard, and even to some degree as a private citizen, irrespective of your employment status. We will also discuss some of the legal protections the law extends to you and under what circumstances they may become necessary to utilize. Some of these matters can be somewhat confusing within the security industry, including the ability to detain persons, the limitations and jurisdictional boundaries of security personnel, and above all, your personal safety. To give us a legal perspective, we have invited Delaware Deputy Attorney General Mark Denny, who is a consultant for Delaware Tech, to speak on the legal aspects of security work. Mr. Denny previously served as a prosecutor in the trial unit, which has jurisdiction over most criminal proceedings within the state. He currently serves as the Director of Civil Rights and Public Trust with the Attorney General's Office. Under his purview are criminal cases involving law enforcement officers and other public officials who have been accused of misconduct. Here now is Deputy Attorney General Mark Denny.
Hello everyone, my name is Mark Denny. I'm a Deputy Attorney General with the state of Delaware and a prosecutor in the Wilmington Trial Unit, which has jurisdiction over most violent crime and non-homicide offenses within the city of Wilmington. An important component of many of our cases, in fact, most prosecutions throughout the state and the country, are the observations of those first on scene. The earliest moments of a case that someone cannot recreate or cannot really fully capture unless he or she was there and observed it. And that's the unique posture that many security guards like yourselves find yourselves in. Security guards have the ability to sometimes prevent crime before it can actually occur or provide invaluable documentation and observations to the police such that those key critical moments are captured and used effectively in any prosecution, or sometimes more importantly than a criminal offense, saving someone's life. So your responsibility is a big one, and it's a great opportunity to make an impact beyond more than just standing guard. Security officers, it's important to realize, are not police. So there are rights that exist to regular law enforcement under Delaware law that do not exist for security officers. That being said, security officers do not surrender their rights, the rights they have as individuals. So human beings in our state have certain rights set out as civilians to protect themselves, to protect their property or a property they're entrusted with safeguarding, and to protect others. Those same rights, of course, that every civilian in this state is afforded apply to you as security guards. So when you are hired by a company, by any department store, by any location or facility, first and foremost, it is critical that you follow the rules of that company. Whatever employment or administrative rules exist within your business, they come first. But secondly, something that you can keep in mind is the importance of the observation and the documentation that you can take to relay out to the police. The police serve the most critical emergency role in the area of crime. When you have the opportunity, and as soon as you have the opportunity, you should call the police for help. Whenever you observe something criminal, reach out for the police. But there are rights and there are responsibilities that security guards can, within Delaware law, employ firsthand either until the police arrive or in an immediate situation when necessary. Use your common sense and follow the key critical components of Delaware law, which will be set forth for you in your training. To highlight initially the most common interaction that security guards may find themselves in with people that are breaking the law is, of course, in the context of shoplifting. Shoplifting is governed by Section 840. That's 840 of the Delaware Code, Title 11. Title 11 covers most crimes, separate from drugs, separate from traffic, actual Title 11 property offenses are included, and they're set forth in 840 as it relates to shoplifting. Look closely at Section C and D and follow your training. Rely on your experience and common sense when employing Section C and D of 840. What that allows is when you observe or you are investigating a complaint as to shoplifting on your store that you're working for as a security guard, you are granted, under Delaware law, limited powers of detention. So regular citizens, an everyday civilian, is normally limited to the type of quote-unquote citizen's arrest that you hear about that never really happens, and that's when they observe a minor breach of the peace until law enforcement can arrive. Security guards, however, are empowered under our statute with more broad detention in that narrow context when we're dealing with an establishment that engages in merchandise or sales and there's an observation or a complaint by one of the store employees as it relates to shoplifting on those premises. Now remember, many of you who work for the mall writ large are not going to have the defense that you're acting as an agent for various stores within. Follow the rules of your employer, follow the rules of the private or the civil guidelines that are set forth, but as it relates to the Delaware Criminal Code, do know that you have detention ability, limited detention ability to go hands-on and detain someone suspected of shoplifting. Now, should be, when possible, limited to your premises. Security guards will find themselves in trouble if they are exceeding their scope, if they are going above and beyond, leaving the premises, chasing people, pretending to be police officers. That's when people get hurt. That's when people themselves not only get sued, but they can also get criminally charged. So be mindful, again, of your rules and the specific guidelines and grants of authority in the areas of detention set forth by subsections C and D of 840. Moving on from the critical grants of authority given to security guards within Section 840 of Title 11, it's important to remember, as I stated, that you as security guards do not lose your individual rights to protect yourselves just by virtue of being in the capacity of safeguarding a particular establishment. Citizens in Delaware have the right to protect themselves, to protect others, and to protect property as set forth by Delaware law. Specifically, Section 464, 464, 465, and 466. They're right in a row. They're a little wordy, but those three sections, 464 through 466 of the same Delaware Code, Title 11, govern the rights afforded to everyone in self-defense. When looking at these sections, it's important to realize where it says the defendant. Normally, we associate the defendant in virtually all cases of criminal law with the person being prosecuted. When it comes to justification, in other words, acting in self-defense, the defendant is you. The defendant is the person who is using the force or protecting others or protecting property. So when it says the defendant under 464, 465, and 466, it's referring to, in your capacity as a security guard, you. So starting first with 464, this governs use of force in self-protection. Again, when reasonable, when faced with an imminent necessity, individuals in our state, certainly security guards included, may use force to protect themselves. There are exceptions that are set forth, but essentially no one has the obligation ever to retreat in the context of their home. No one has the obligation to retreat in their workplace unless you started it. So the wording is, if you're the initial aggressor, you don't get the same right to retreat safely or the same protections if you do not retreat in the workplace. But generally speaking, if someone's at work and if someone's at home, that would include you as security guards being at work, you do not need to retreat and seek safety if, again, the use of force in protection of yourself is immediately necessary. There's a context within this section that's carved out for use of deadly force. Obviously, that's going to be largely, if not exclusively, applicable, hopefully, to police officers. But again, as we know, citizens throughout this state are afforded the right to use deadly force in circumstances, certainly in their home, certainly the protection of others, and it's simply a heightened standard. So this won't surprise anyone if deadly force under our law is going to be considered justified, the defendant, one person, must be faced with the threat of deadly force, serious physical injury, death themselves, or the threats of either rape or the threats of kidnapping against another. So in those circumstances, an individual will find justification under Delaware law in using deadly force to actually defend themselves. So moving on beyond the use of force in self-protection is the use of force for the protection of other persons. This is justifiable to protect a third person. So beyond just you, the aggressor, when you're protecting a third person, if you're covered in defending yourself, you're covered against defending the third person if the same threat exists. Also, under the circumstances as you, the defendant, believe them to be, the person whom the defendant seeks to protect would have been justified in using protective force. So if the third person, if the person who's harmed would have been justified as an individual, you as a security guard are also justified under this section. And then lastly, the defendant believes, you believe, that the intervention is necessary for the protection of the other person. Look closely at the requirements for when someone's obligated to retreat or to give up something with a demand before using the force in self-protection. There's no obligation to retreat when you're protecting someone else unless you know, and it's difficult to know, but if you do know under the circumstances that you can secure the complete safety of the other person, there actually is an obligation to retreat. It's a complicated area of the law, but what's important to realize is where to look, what to consider, use your reasonableness and your common sense, and if you're acting in most instances to protect yourself against an imminent threat, the same protections are going to allow for other individuals, third parties, fourth parties, in your vicinity if that threat exists. Moving on lastly to the use of force and protection of property. So in traditional common law, it's rare that individuals are allowed to use force to protect property, but it does exist. So a lot of these circumstances, again, apply to a homeowner, and if someone is certainly being sought or ejected from their property, they're allowed to use deadly force if someone's coming to take over their home, for example. But the other situations for using something like deadly force to protect property have to be extreme. You see someone about to commit an arson on your property. You see someone about to commit a kidnapping or a robbery on your property. Deadly force will be allowed. But just general use of force and protection of property has more carve-outs. So again, it's allowed, and in your context of security guards, you have that right, but there's more carve-outs, in other words, more exceptions or more things that would have to exist first in order to get there. So the statute, for example, and something that you may find in your training, requires an attempt to basically talk the person out of it, shout them down, give them some demand. Give them a demand to stop what they're doing before you have to resort to the use of force in protecting property. But then there's an exception to that, and the exception to that is unless it would be useless. So if the circumstances are such that someone engaging in a very deadly act against the property or against others on the property, if to simply warn them or shout at them or tell them to stop or to make a demand would be useless, you do not have to engage in that demand attempt. Also, it's important to realize that there's going to be an exception if substantial harm would be done to you before you can actually effectively make the request. So in addition to it being seen as a fruitless or a useless exercise, if you're about to be hurt and if someone else is about to be hurt, instead of simply telling them to call for help or telling or insisting under the law that you shout down or tell the person to stop, if that's going to be a situation that causes substantial harm to you, you do not need to make that request. Just something to keep in mind. Obviously, it makes sense that the protection of a person would be paramount to the protection of property. People can dispense with property. It's not going to be the end of the world. It's just going to be a monetary loss. So Delaware law is not going to recognize the same protections when someone's simply trying to protect merchandise or property or damage the same way as they would, of course, when they're trying to protect life. Again, rely on your training, pay close attention to the rules of your establishment or your business, but don't forget, you're an individual under Delaware law that possesses the same rights as any other individual when it comes to safeguarding your own safety and the safety of others.
Okay, so Mr. Denny discussed several topics as to the legal standing of a security guard. He, in fact, provided a decent amount of information which we will now hope to unpack for everyone. A smart security guard will always consider 2 to 3 sources when considering or undertaking most actions in their line of duty. Mr. Denny concentrated on his area of expertise, which is the law, but he also cautioned you to fully understand and follow the practices of your employer. Security guards should view decision-making on the job almost with the idea of it being a triangle. One side being the officer, another side being his or her employer, the security agency they work for, and to some degree the third side being the client. In our opening segment over here, we discussed the company and client relationship. You need to be careful because they may not always align, they being your company and your client and the decisions that you're making according to the law. Now, the law applies to everyone, and your client or company cannot supersede the law. For example, the law does not permit security guards to issue traffic citations. Therefore, your company or your client cannot somehow empower you to pull over vehicles and cite drivers for speeding violations. On the other side, the law does not compel security agencies to grant authority to security guards in an employment circumstance. For example, Delaware law provides some legal authority for a merchant's agent to detain shoplifters in Delaware in certain circumstances. Your company and or your client may restrict this and not permit you to detain anyone. While the law may allow you to detain, your company is saying no, so that is what you need to follow. Let's review the role of a private security guard in Delaware, which has 4 main components. Security guards will find themselves in the unique posture of generally being the first person responding to an incident. As Mr. Denny previously indicated, their observations and initial overview are key factors which may assist law enforcement in prosecutions and prevent a criminal incident from continuing in an area where the guard is assigned. Security guards should also maintain a high level of vigilance and always be situationally aware. They are also in a unique posture to prevent or deter criminal activity with their presence and ability to immediately request law enforcement. Security guards are normally assigned to the private property locations where their security agency has a contractual relationship with the private property owner or manager referred to as the client. The client has recognized the need to have personnel in place to be the eyes and ears of the property and to protect the property assets and the persons who visit. Security guards, again, are in the unique posture to be vigilant for specific property issues, defects, and hazards which could jeopardize the safety of persons and the property itself. They can also take immediate preventive measures to mitigate further loss. Security guards not only act as protectors and risk assessors, but they are the ambassadors providing customer service at their private property locations. Visitors often have their first property interaction with security personnel when they have questions, need directions, been the victim of a crime, sustained an injury, or experienced a medical condition. The security guard should anticipate all such interactions and even more. They should be competent about the property and willing to assist in any manner possible based on their training, the property security plan, and other protocols. Security guards may interact with persons who are in a crisis or state of distress. They have been the victim of a crime, had a medical issue, etc., and they may need to potentially render assistance. They may also respond to incidents prior to emergency first responders being on the scene. They must understand the full scope of their training, the scope of their employment, but always consider their personal safety. Regardless, security guards will be seen as leaders in a crisis or an emergency and should have the confidence to act accordingly. We will expand upon the very limited legal authority a security guard may possess. But first, let's discuss the idea of a security guard and their role as an authority figure in general. Any authority they would have is derived mainly from their client property owners who hire the guard to provide the four components we just spoke about. The idea of authority would be in the enforcement of a client's private property rules or codes of conduct which the property owner or manager establishes. They then hire the guards as their rightful representatives with the expectation the guard will enforce these rules and codes. Lastly, security guards must certainly understand any authority they have to enforce private property rules and codes exists only on that property location. They have no jurisdiction off of their client's property. Being crime prevention is outlined as a role for security guard is most likely where the idea of arrest or detainment of criminals might come about. But enforcing criminal laws fall under the authority of peace and law enforcement officers, not security. In turn, security guards need to understand their role in deterring crime is different from the idea of enforcing criminal laws. Perhaps one of the more confusing aspects of a security guard's authority is the ability to arrest or detain a person. First off, let's define detainment and arrest. Both terms can basically fit the same definition of preventing a person from freely moving about or being able to walk away. When you detain somebody, you are taking them into your custody. The act of detaining somebody is a significant interruption of a person's civil rights, and your ability to take such actions needs to be examined carefully. For law enforcement, detainment is different from arrest in that a detainment allows them to hold a person temporarily to conduct an investigation. In the very limited circumstance of a security guard being able to detain someone during a shoplifting incident, it would be for them to allow law enforcement to arrive and determine if a criminal arrest is warranted. We'll explain reasonable suspicion and probable cause when we discuss the burden of proof. Detainments or arrests can legally be conducted in Delaware by a person who has explicit statutory authority to do so. This authority exists almost exclusively with persons defined as peace officers, which include all sworn law enforcement officers, which are mainly police officers at any level, state, county, or municipal, or any other legal designation. Fire marshals are as well, probation and parole officers as well, and federal law enforcement officers. Commissioned constables in Delaware also have limited arrest authority, although it only extends within their property jurisdictions. We all understand police officers and their role in enforcing the law. It is particularly important for security guards to understand their role in comparison. Our goal should be to work cooperatively with them. The police can play a vital role in our activities as security guards, and it serves us well to be very familiar with their functions as opposed to ours. Now, in Delaware, police agencies have various jurisdictions. It is not uncommon in the state to have one larger agency, such as the state police, with a very wide jurisdiction, as there are less individual small town departments than some other states. New Jersey, for example, is a state where the idea of home rule is prevalent, and almost every town, no matter their jurisdictional size, normally has their own individual police department. In Delaware, there are several areas which are unincorporated, and normally one of the larger agencies would have jurisdiction. In New Castle County, for example, the county police extend into most communities. However, entities abutting a state highway would fall under the state police's jurisdiction. Not to get too confusing, but just to kind of give you a layout of the way police are deployed in the state. In Kent and Sussex County, normally the state police will be the agency to handle criminal incidents in unincorporated areas. There are local towns and cities within the state with their own police agencies, such as Dover, Middletown, Rehoboth Beach, and others. Wilmington has the largest city agency in the state. Beyond peace officers and federal officers, some other persons who possess limited authority to detain would include Justice of the Peace Constables who operate in Delaware courts, who possess limited detention authority, and, as mentioned, commissioned constables who mainly operate in hospitals and schools. However, their detainment authority only exists again within their employment jurisdictions. There is also limited authority to detain a person suspected of shoplifting provided to a merchant, store supervisor, agent, or employee of a merchant, as outlined in subsection 840 of the Delaware Criminal Code, Title 11. Security guards are not peace officers in Delaware. In fact, the only classification from the persons outlined to have authority to detain which might apply to a security guard would be that of an agent of a merchant. We will fully discuss these circumstances as we proceed. Arrest is best defined as the legal authority to take someone into custody so as to ensure they can answer for the commission of a crime. This then involves the arrested person being brought to a court before a judge or a magistrate who would determine if that person can be held or granted bail or other circumstances. Arrests can only be conducted by peace officers. An arrest occurs when a peace officer has probable cause to indicate the arrested person has committed a crime or there is a warrant issued by a court for the person. Persons with limited detention authority, such as constables or merchants and their agents, detain persons with the intent of a detainee being legally arrested by a peace officer or law enforcement officer, which is the same thing. Citizen's arrest was a common law concept from Europe even before the United States was established as a country. It was practical in medieval times when there was no organized law enforcement and citizens were empowered to apprehend criminals by command of a king or other government entity. Citizen's arrest legally existed in most states in the United States, but diminished as formalized police and law enforcement was established. Most states have abolished the concept of a citizen being able to arrest or detain a person or another citizen. Mr. Denny mentioned the idea of a citizen's arrest and described it as something rare or hardly ever occurring in Delaware. Regardless, in July of 2025, the law was updated in Delaware with House Bill 153, which outlined the intent of this provision is to eliminate any doubt that a citizen's arrest is not permitted in Delaware. So the idea of any private citizen, including a security guard, to make a citizen's arrest is no longer practical. Also in 2025, House Bill 152 broadened the statute to criminalize impersonating a federal officer. It had already been illegal to falsely claim to be a police officer, firefighter, emergency medical technician, paramedic, or fire officer. The new law ratchets up the offense from a Class E to a Class D felony. For now, let's look at something which is entirely defined as a law enforcement function, but has some comparisons to security duties. My goal is not to have a criminal law class, but simply to explain the distinction, yet the nexus to security work. Police often encounter suspects of criminal activity and begin to question them. For example, police responding to a burglar alarm and observe a suspect running from the scene might be apt to stop the person and question them based on this unusual or suspicious circumstance. This is known in police world as an investigative stop or a Terry stop. Terry versus the state of Ohio, a precedent-setting case from the 1960s. You may also know it or have heard referred to as stop and frisk. A Terry stop or stop and frisk basically means a police officer may engage a suspect in a conversation. And in order to protect their safety during that conversation, the police officer may conduct a cursory pat-down of the suspect to establish that there is no physical threat to the officer, for example, a weapon or something else that could endanger him or her. Now, the results of that conversation that the police officer is having with the person or the search may prove to be the eventual grounds for the suspect's arrest, or could potentially eliminate them as a suspect. Security guards cannot make investigative stops of suspects except for the one exception I have alluded to, but will explain a little bit further regarding shoplifting. Now, with that said, we need to consider the work of a security guard. They will encounter persons on private property locations where they're assigned to protect acting suspiciously, perhaps even breaking the law and committing a criminal act. Does this mean security will ignore this activity and simply move on? No, obviously they will not. But there is a difference in your intent. Your intention as a security guard would be to protect the property or the persons at its location. Your intention would not be to arrest the suspect or seek to have him or her prosecuted, even though that may be eventually what happens with the intervention of law enforcement. So here is what a security guard should avoid: questioning persons with the intent of having them arrested, or making accusations, or even asking investigative questions. Granted, this will be somewhat difficult to avoid, say if you see a suspect with a person's cell phone in hand and the victim is yelling, "Hey, that person took my cell phone." Again, just remember to articulate your intentions. You spoke to that suspect to find out what he or she was doing, and that will always happen in security work. So don't be overly concerned about what you may or may not be saying to a suspect necessarily. You also have no legal obligations to advise suspects of their rights as a police officer would under the Fourth and Fifth Amendments. So there is a distinction, and here is the nexus. If you are enforcing property rules and regulations, some of them can be illegal acts. They're not always, but regardless, you're performing your duties as a security guard. And you might come across people that, for instance, are violating the property rules and regulations. Maybe they're trespassers. They're not supposed to be on the property. They were previously banned. Maybe it's somebody who's acting unusual or contrary to normal conditions associated with the property. They're being suspicious. You're going to be approaching these people. You're going to be having conversations with them. All right? And all of this constitutes situations which are normal issues for a security guard to be dealing with. There is hardly any case law which clarifies the distinction between security personnel and police officers making arrests in Delaware. And this is probably good, as it does not seem there are numerous examples of this happening. Being fully transparent, there were times when I was in the industry when security guards did detain a person or persons outside of shoplifting incidents. One particular incident which stands out were two security guards who held a male who had pushed a female to the ground and took her purse. The police were glad to have a suspect waiting and being able to take him into custody. A defendant would also need to legally challenge in what is referred to as suppression of evidence, where all aspects of a criminal case are examined to make certain that a defendant's rights have been upheld. Regardless, security guards detaining anyone, even in exigent circumstances, is not encouraged and would be a very rare occurrence. State versus Varojas is a more than a 40-year-old case where a security guard detained a male for suspicious activity at the Dover Downs Casino. The Dover police ended up arresting the male and charging him with a crime. But upon a suppression of evidence hearing, the case was dismissed. The judge in this particular case observed the suspect had been arrested by a security guard who had no authority to arrest the defendant. This does not mean the suspect or the defendant had not actually committed a crime, just the method of his arrest and the methods for developing evidence against him were improperly legally applied. By Delaware statute, only a peace officer may detain a suspect to develop probable cause that a crime has or may have been committed. So you may be saying to yourself as a security guard, what is my role when observing or interacting with criminal activity? This is one area where not only you are confused, but the public may have a misconception as well. Well, many people are quick to point out how security guards lack the authority of the police, especially those who are actually breaking the law. Other people may believe security guards have an absolute duty to perhaps detain a suspect or investigate criminal activity. Security guards should consider themselves as being a go-between, meaning between the incident and the interaction with law enforcement, if you will. Security guards absolutely have a role to play, and if they understand it, it can be a very valuable resource for law enforcement in investigating criminal incidents. These are some of what we call alternative measures for security guards, such as contacting the police to request assistance if they're seeing criminal activity, maintaining surveillance from a safe distance on CCTV if available. That is a very, very good resource. And recording any kind of suspect details, descriptions, directions of travel, etc. All of that information obviously can be relayed to law enforcement when they're beginning to conduct their investigation. During this presentation, we have alluded to one legal carve-out in Delaware law where security guards have legal authority to detain, which is in the case of shoplifting or retail theft. But you, again, are reminded to fully understand the law and the directives from your company and your client. Not all company and clients will allow you to detain or even make contact with shoplifters. Shoplifting in Delaware is defined in Title 11, Section 840. Generally, theft under $1,500 is considered a misdemeanor, while theft over that amount is a felony. There are several things which would constitute a shoplifting in Delaware. Shoplifting offenses in Delaware include any of the following. Most often, it is the removal of merchandise with the intent to deprive the owner, which means not paying for merchandise. Normally, this occurs when a person removes merchandise from the last possible point of sales, such as a register stand, where someone leaves the retail store with merchandise they have not paid for. Next would be a person purchasing merchandise using someone else's identity and doing so without their permission. For example, using a person's credit or debit card without their consent. Concealing of merchandise means someone picks up an item for sale in the store and hides it or places it out of view. For example, a shoplifter picking up a pair of earbuds from a display and hiding them inside their jacket. Incidentally, in this case, the moment someone conceals merchandise, they have committed a shoplifting. It is important to note most retailers will not stop a shoplifter for simply concealing and normally wait for the shoplifter to exit the store or again leave that last possible point of sales. The fourth type of offense is somewhat outdated, which is altering a price tag. Today, most retail items have barcodes, but years back, price tags were applied to merchandise and thieves would remove, let's say, the $500 price tag and put maybe the $50 price tag on the item, so it rings up for $450 cheaper. This is called underringing, and it could also be done by the clerk or cashier who acted in concert with the shoplifter. It could still occur today, but technology makes it somewhat impractical. Shoplifting also applies to an offender who hides merchandise in the packaging of another item with the intent to steal it. An offender who uses an instrument like a falsified credit slip to obtain merchandise without paying for it, or possesses or uses counterfeit receipts or universal product code labels with the intent to defraud the store owner, all of this would be considered shoplifting as well. The criminal penalties in Delaware for shoplifting depend on whether the theft was over $1,500, which is a felony and normally considered organized retail theft. Amounts stolen under $1,500 are misdemeanors. Prosecutors can also downgrade felony charges for plea agreements, but not always. There can also be civil penalties as well. A person who commits shoplifting, or the parent or legal guardian of a minor who commits a shoplifting, can be held civilly liable to the store owner. Merchants can legally pursue a shoplifter criminally and civilly. In my experience, normally merchants choose only one method. In addition to civil and criminal penalties, and sometimes in lieu of either, a merchant may simply choose to ban or trespass a shoplifter from their store. This process is normally not a police matter. However, the store can also request the court impose such a sanction on an accused shoplifter or have this added as a condition to their criminal penalty. Shoplifting laws and your ability as a security guard to assist can get a little confusing. So stick with me here because it may sound like I'm telling you not to arrest or to detain, but then saying there is a minor exception to this for security guards assisting a merchant in detaining a shoplifter. Well, if that's what you're understanding, you're actually correct. I said a few minutes ago citizen's arrest has been eliminated in Delaware law, and yes, that is true. But the language of that bill does contain an exception for shoplifting. It's highlighted here and is saying there is limited authority to detain a person suspected of shoplifting provided to a merchant, store supervisor, agent, or employee of the merchant. Security guards under the correct circumstances may act as that agent. In order for you to be that agent, the security agency you are employed with needs to have a direct contractual relationship with that merchant. It is essential to understand who you actually work for and if you are permitted to make shoplifting stops. This is again an area where the public gets confused, merchants get confused, even security personnel, they get confused as well. All of them may believe a security guard can detain any shoplifter, like the police can arrest any type of a criminal. That's not necessarily the case over here. So again, the law allows security guards to assist merchants with detaining shoplifters, but you need to understand who the merchant is. Does your security agency have a direct contractual relationship with them? As an example, when I worked at the mall, we worked for the ownership of the mall. Our job was to protect and provide security for the common area of the mall, the parking lot areas. It wasn't to go into the individual tenant stores, the JCPenney's and Macy's and the Gap and Victoria's Secrets, and do their security work or stop their shoplifters. Oftentimes we would get called for assistance in those situations, and that would be responding simply to maybe keep the peace, make sure that there wasn't any disturbance in the common area or anything else like that. We weren't responsible for taking that shoplifter into custody, going to court later on, or anything that was associated with that. We couldn't because, again, our company didn't have that contractual relationship with these individual tenant stores. Now, let's say your security agency has a contract with a local pharmacy, Rite Aid Pharmacy, let's say, and your job is assigned to go and work at various Rite Aid pharmacies. Being they have a contractual relationship with your company, if they choose to, they can detain shoplifters, and you legally can assist them in that kind of a circumstance. So again, you need to understand, all of these parameters and how they're set, obviously. And again, it can be a little bit confusing, but what you really want to understand is what team you actually play for. So beyond this, there are legal ramifications. If you're not, in a position to detain a particular shoplifter, you can't appear in court. Okay. You also, if something goes wrong with that stop, or it was bad from the beginning, in other words, the merchant really didn't have good reason to be able to stop that shoplifter, and there's legal a lawsuit or whatever that's preferred against that tenant later on, you can become involved in that as well, and so can your company. So again, another reason why you want to be careful about those things. Again, I understand this is a little bit confusing, but really it comes down to, okay, who do I work for, and what is their contractual relationship with this particular tenant or this particular company. Okay, and if it doesn't exist, then that's where you have to draw the line, particularly in these shoplifting incidents. So here's what the actual statute says in Title 11. A merchant, a store supervisor, agent, or employee of a merchant 18 years of age or older who has probable cause for believing that a person has intentionally concealed unpurchased merchandise or has committed shoplifting as defined in subsection A of this section may, for the purposes of summoning a law enforcement officer, take the person into custody and detain the person in a reasonable manner on the premises for a reasonable amount of time. Well, now let's parse this out a little bit because there's a lot that's packed into here. So first thing, a merchant, store supervisor, or agent, okay, we have already established that, you as the security personnel, you're their agent. You're the agent of a merchant, all right? A merchant that actually wants to stop shoplifters, and the agent or the security guard who has permission from their company to do so, all right? So we want to establish that. 18 years of age is fine because security officers have to be over 18. Probable cause, that's something that we're going to talk about in a minute over here, and that is a legal threshold that you want to know and understand before you're actually stopping somebody. All right. Summoning law enforcement officers. So in other words, your intention over here is to stop somebody in order to have them prosecuted for shoplifting. So another thing that you want to be mindful of is there are certain merchants that they simply want to stop a shoplifter and take back their merchandise, which legally speaking they can do. That's fine, but again, when you're involved in this shoplifting stop, the intention should be to have that person prosecuted, not simply to get the merchandise back. If that's what ends up happening, and oftentimes that does for a number of different circumstances, but I just want to point out, how the law specifically applies in this circumstance. Take the person into custody, detain the person in a reasonable manner. That's somewhat ambiguous as well. Obviously, we wouldn't mean that, the security people or the merchants are, beating the person down or anything else like that. That obviously would constitute a whole nother set of circumstances that we wouldn't, or a road that we wouldn't want to go down. But on the premises for a reasonable amount of time. Okay, I can't legally tell you or define what a reasonable amount of time to hold a shoplifter is. Now, and I mentioned before, law enforcement resources in Delaware are somewhat limited at times. So you could be waiting realistically 2, 3, 4 hours for law enforcement to arrive and actually come in and take that person into custody. So how long is that person going to be held in custody? That is also a conversation you want to have with the merchant beforehand. If we're going to stop this person, how long are we going to hold them before the police come? Are we going to wait that 2 hours? Are we going to wait 15 minutes, 30 minutes, whatever it is? And the merchant really has to set those parameters because they aren't specifically set in the law right now. The only thing that I can give you as a vague reference is that in the Delaware Constitution, law enforcement officers have a 2-hour window in order to hold somebody during an investigation before they're required to charge somebody. But should that be used as a comparison? I really don't think so. But that's the only legal comparison that I can think of. So again, you want to take a real good look at this statute and discuss it with your merchant and see how all these questions that are brought up because of this are actually answered by them. So if you're legally permitted to detain a suspected shoplifter under the correct circumstances, what are you actually being excused from? As Section 840 continues, it outlines that an agent or others shall not be held civilly or criminally liable. You should also note this exception in Section 840 of Title 11 requires there to be probable cause a shoplifting has been committed. It will be important to understand the difference between reasonable suspicion and probable cause, and we will review that in a moment. So if the scenario exists where you are in a position as a security person to be able to participate in shoplifting stops, your company is aware of it, allows it, your company actually has a contractual relationship with that business or merchant, and that merchant wants to make shoplifting stops. They have a good program in place to make sure that that happens. They have their steps in order and everything else like that. What you also need to understand is what we call the burden of proof. And again, not to make this a criminal law class, but just to understand the steps that would be involved over here. So the criminal burden of proof draws down to 3 different steps. It starts off with reasonable suspicion, proceeds to probable cause, and then there's proof beyond a reasonable doubt. Reasonable suspicion is a point where you believe that a criminal act might have occurred, and you may have some circumstances that are present. Let's say you have a display case with 10 pairs of jeans on it, and about 5 minutes later you observe that those 10 pairs of jeans are missing, and there's 3 or 4 people that are standing around. And you're potentially taking a look at the cameras and everything else like that, and you have in your mind at that point in time that maybe those 3 people, 4 people, whatever, were potentially involved with stealing that, right? Okay, you're not sure at that point in time. Okay, then you go and you examine the cameras, you take a look at it, and one of those people actually was the one that picked up the 10 pairs of jeans and they walked out the door with it. All right, that's a point where you have evidence. That's a point where you have probable cause. That also is the point where it's logical to be able to detain somebody for shoplifting, or at least have the merchant detain somebody for shoplifting. It's also the point where when you're going to court later on, or the merchant's going to court later on, they can actually say, yes, this is why we stopped this person for shoplifting. We had evidence. We had probable cause. And then the third part is, again, proof beyond a reasonable doubt, and that's when somebody is going to court, to trial. It's a criminal appearance that they're making, and then, the judge or a jury would establish that they're guilty because it's proof beyond a reasonable doubt. And that's, again, based on the evidence that's provided in your probable cause. So just that we're sure about these legal definitions, the difference between reasonable suspicion and probable cause. And there's a reason why I'm going to great lengths to be able to point this out. Reasonable suspicion is the step before probable cause, and at that point you have what appears to be a crime that may have been committed. The situation escalates to probable cause when it becomes obvious that a crime has been committed. And the thing that makes it obvious, again, is evidence. Now, evidence can be CCTV footage. It can be a witness telling it. It can be you or somebody that's near the scene, a manager or whatnot, that actually witnesses the shoplifting in this circumstance occur. Okay, that's your evidence at that point in time, and that's where it becomes probable cause. So it's important for you to be able to distinguish the difference. A lot of times merchants will have that first step in line, and they'll have a lot of suspicions, but they won't have anything to conclusively say, yes, this person actually did this. And if you don't, when you go to court, you're not going to be able to prove that case, and it's going to be thrown out. And then that's when a merchant has the potential to face a false arrest suit, those type of legal ramifications. All right, so let's just test our knowledge just so we're perfectly sure about this. So let's say your scenario is a store customer is observed picking up merchandise from a display rack or counter and then moves towards a secluded corner of the store, crouches down, and appears to be placing items inside his or her jacket. So what you want to ask yourself right now is, do I have reasonable suspicion, or am I at the point of probable cause? Am I at the point where I still have to continue to observe things in order to have evidence come about? Or do I have evidence at this point in time in order to be able to stop that person for shoplifting? All right. I can't poll the entire question in the way that our class is set up over here, so I'm going to give everybody the answer. And the answer in this scenario over here is you only have reasonable suspicion at this point. because you have not observed the person actually take something at this point in time. Okay, you don't have enough to go and stop them. You have really good suspicion at this point in time, and more than likely, yes, it's going to culminate in this being a shoplifting. You'll have that probable cause in place, but you're not there yet. All right, so you want to be careful about that threshold. Okay, so one more knowledge check question over here. So let's say your scenario now is a security guard observes a person via CCTV actually hold a store product, merchandise in their hand and stuff the item in his or her coat. At this point, you have probable cause because you're seeing the actual criminal act of shoplifting being committed. And even if you weren't witnessing it on CCTV, if an eyewitness was witnessing it or you were witnessing it, that's still probable cause at that point in time. All right, you have direct evidence to say, yes, we've seen this person put the merchandise in their pocket, in their jacket, wherever they concealed it. They've committed a shoplifting at that point in time. All right, so just so you absolutely understand the difference over there. Not real difficult when you kind of take it apart and examine it at these levels over here. So make sure you're doing that, if you are involved in these shoplifting scenarios. Taking anyone into custody, prohibiting that person from freely moving about, is detention. And it is a matter which should be considered very carefully, with very clear understanding of the law. So let's make certain you understand the very limited role you might play in detaining a shoplifter as a security guard. First, shoplifting detainments should only be made when there is probable cause. Reasonable suspicion is not enough, and be careful, as merchants may not understand the law, or they may choose to ignore how it needs to be legally applied. Next, fully understand your security agency or company's relationship to the merchant. If you are a guard, let's say assigned to patrol the parking lot of a local strip mall, your company most likely does not have a contract with the individual stores in that strip mall. So you can't simply assist them with their shoplifting incidents. Finally, fully understand who you work for. The simple way is to ask your agency or company who you are able to assist with shoplifting issues, if at all. Again, your company may prohibit you from being involved in shopliftings altogether. Lastly, detention for security guards would only be applicable in shoplifting incidents. There is no other legal authority in Delaware for a security guard to detain. Let's put aside detention and arrest for a moment. In security work, you may often find yourself interacting with the police, requesting their assistance, or maybe being on the scene of an incident, or arriving at a scene where the police have responded as well. First, remember your role and don't confuse it with the role of a sworn law enforcement officer. The police have a very specific and legally defined role to play, which is often to enforce the law, and in some cases hold persons who violate the law accountable by detaining or arresting them. The police also have great latitude in detaining to investigate an incident, as we have spoken about earlier. Still, there may be times when your assistance to the police can be very practical. Your initial interaction with a responding police officer may tell you something. For example, are they looking for your help? Be ready to receive that message. Or, conversely, if an officer seems like they wish to operate without you, then stand back and continue to be there should the circumstances change. In my experience, the police normally seemed very amenable to assistance, which can be provided in many forms. When we later on review security responding to criminal incidents, we will elaborate further on assisting the police. Police and law enforcement officers are sometimes placed in circumstances where they need to lay hands on a person or persons in order to effect an arrest or legally control them in some manner. These interactions can be dangerous to the officer and anyone involved. A police officer physically struggling with an adversary can escalate and sometimes result in serious injury or even death. Normally, these interactions have weapons present or utilized. The police certainly have weapons, and keeping them secure when fighting an adversary is another concern, adding to an already stressful event. A citizen or a security guard lending assistance to a police officer is legally acceptable. However, in a struggle, you need to understand your personal abilities, vulnerabilities, and physical limitations as a practical matter. Not everyone is prepared or capable of a physical battle, and that is obviously an individual decision you would need to make. You may also be able to keep others from attempting to interfere or getting near the officer. It would really depend on the actual circumstances. But even if physically intervening is not possible for you, there are other methods such as requesting additional assistance, calling 911, or anything else that might be practical and allow for the police officer to safely bring the struggle to a safe conclusion. There actually is law in Delaware whereby a police officer may command a citizen to assist them, and should the citizen unreasonably fail to do so, they could be arrested themselves for a misdemeanor. But again, assisting does not need to be physical. It can be pretty much any effort to lend assistance. In addition, the law also provides legal protection, meaning you would not be held liable for any damages so long as your assistance was deemed to be reasonable under the circumstances known to you at the time. Now, I would also add that physically needing to assist police officers most likely would not be a routine matter for you. Police are normally well trained to react to a physical threat and request additional police assistance when they perceive their threat environment might warrant it. Regardless, knowing how you can most appropriately and legally assist those who normally are tasked with assisting us is important. During my time in the industry, I came across, or at least had knowledge about, security personnel simply ignoring most of the lessons we covered here today. Sometimes thinking they were really doing the right thing or their means might justify the ends. Simply not understanding their role. Some examples I can tell you about, and thankfully not always from first-hand knowledge, include security pursuing shoplifters onto a busy highway, knocking people over as they ran, leaving the property that they are assigned to protect to pursue suspects, chasing as opposed to surveilling, using vehicles to intercept suspects, having a suspect steal the security guard's vehicle, pretending they are police and attempting traffic stops, overreacting to a verbal threat, using a weapon when there was no actual threat, the guard that needs to wear the uniform off duty where they are just by chance going to be spotted as maybe being a cop, and on and on. So please respect the industry you will now be a part of and always strive to do the job the right way. In this segment, we spoke about the legal and correct way to do your job. When an employee, but especially a security personnel employee, operates outside the scope of their employment, the law, or otherwise oversteps their authority, they put everybody's personal safety at risk. They put their employment in jeopardy and may even find themselves being criminally liable or vulnerable to legal action. As we conclude this segment, and we will expand in other training segments, hopefully you will be provided with the legal and practical parameters relevant for every security professional. So pay attention to the law, your employer, who is hopefully training you as well, and above all, pay attention to your common sense, and you'll be fine. Thank you for your time.